It's another big day on Capitol Hill. The House of Representatives is getting ready to vote on a measure that would formally call on Vice President Mike Pence to invoke the 25th Amendment, effectively stripping President Trump of power. They accuse the president of encouraging the rioters in Washington last week who killed at least one police officer after they breached the Capitol building. And in an unprecedented move, House Democrats are introducing a second article of impeachment, charging the president with, quote, inciting violence against the government of the United States. For more on this, let's bring in Jessica Levinson. She's a professor at Loyola Law School in Los Angeles. A lot of L's there, Professor. Good to see you. Thanks so much for being with us. So let's talk about the 25th Amendment. Section 4 of the 25th Amendment has never been invoked in our history. How would you expect to see that play out today?
Well, I wouldn't expect to see it play out. I mean, what I would expect is that there would be a resolution that Congress is going to try and put a lot of political pressure on the vice president. But what's important for people to know when it comes to Section 4 of the 25th Amendment, which, as you've said, we've never used in our nation's history and was just, frankly, ratified to try and fill a gap we didn't know about. We didn't know what would happen if the president was alive but incapacitated. The important thing is that all roads lead through Vice President Mike Pence. There's a couple of different routes he can take. He can either try and convince a majority of the 16-member Congress, or he can try and convince a majority of his separately created legislative body. But he's the one who has to say the president is unable to fulfill the powers and duties of his office. That's the takeaway here, and I don't think he's going to say that. If he does, then the President of the United States actually could contest and say, no, I'm fine. He would then force the vice president to double down, say, no, you're not. That would trigger a vote of Congress. While that's happening, the vice president would be president, and that would run out the clock on this particular administration. But I don't think that's going to happen.
So then we move on to sort of what looks like the next step in this whole process, right? Democrats are going ahead with introducing articles of impeachment. That's the plan as we understand it. Once again, you talked about the clock running out. Once again, the president only has days left in his presidency. If he is, in fact, impeached, he would likely not be in office by the time this whole thing wrapped up. So what would that actually look like?
Yeah, so what it would look like, again, something we've never done in our nation's history, which let's pause for a minute and say that's a good thing, right? It's good we're not in a situation where we're constantly talking about impeaching presidents. It's good that these are rarities. So I think what this would look like is that the House of Representatives would very quickly impeach the president on a simple majority vote. That's all they need based on that one article of impeachment. The case would then be essentially referred to the Senate. For people who are thinking about a criminal case, the House is essentially saying there's enough there. Now, Senate, you go to trial. The Senate would likely go to trial after President Trump's term. They would then have to vote by a supermajority, 2/3, that would require 17 GOP senators to convict the president. And at that point, they could then make a decision what the sentence would be, what the consequence would be. I think this is why there's still a purpose, even though he would no longer be in office, so you couldn't remove the president. The purpose would be to say, and the sentence is, you don't get to run again. You don't get to campaign again. You don't get to raise money again. And so that's one of, when people are saying, what would the effect be? That's one of the effects of still going through with this late in the day impeachment.
Professor, you wrote a piece for the Chicago Sun-Times about the Founding Fathers and how they would have perceived, for example, President Trump's ability or lack of ability to pardon himself. And I just given your learned experience, do you think that they anticipated somebody like President Trump? Because the 25th Amendment is fairly vague. Even the impeachment, the way that the impeachment articles are worded are fairly vague. I do know that in Federalist Papers, Alexander Hamilton, I want to quote this for our viewers because I've always thought that this was an interesting quote in Federalist. In the Federalist Papers, Alexander Hamilton wrote this, that impeachment responded to, quote, those offenses which proceed from the misconduct of public men or other words from the abuse or violation of some public trust, and are political because they relate chiefly to injuries done immediately to society itself, chiefly to injuries done immediately to society itself. That's Alexander Hamilton. Does that not fit what we saw happen on Wednesday?
Oh, I think it absolutely does. And I think you quoted the key part of the Federalist Papers there, which is that what the founders were worried about wasn't somebody who engaged in a private transgression, let's say. It really was a public offense, something that went to what they do as somebody who holds public trust and directly undercutting that trust. Even though it's terrible to commit a crime, what they are envisioning, for instance, wasn't a DUI. It was something more along the lines of using the power, for instance, of the presidency and using it against the people you are supposed to serve. Now, so what did the founders intend when it comes to a self-pardon? That was a hot summer when they debated this, and there was a lot of debate about whether or not the pardon power should even be included. In the end, they said yes, because the president could essentially act as a fail-safe and provide, quote unquote, mercy in situations where the federal criminal procedure, where federal criminal law had, created an outcome that just wasn't just. That's not what we're talking about when we're talking about self-pardons. I don't know if the president will try. It will create a really fascinating constitutional question. The founders essentially thought we were all going to lie to each other a little bit. That's why we have these three branches of government, but that no one would transgress so much. The question is essentially what the Supreme Court would say, and I think that they would say no. The self-pardon is not proper under the Constitution.
So we have heard people argue, though, that President Trump's speech is, protected. It's a part of his First Amendment right, freedom of expression. Is this a valid defense? All speech is not protected, and the president is though in many ways, like every other American, in many ways he's not.
Exactly. Well, one thing to think about is when we're talking about whether or not the First Amendment is a defense. In an impeachment case, the federal rules of evidence don't apply. So we're not talking about courtroom rules. And an impeachment case and an impeachment defense, you don't even really need to prove that there was a criminal violation in order to impeach somebody. Again, it's more about a public offense. If we're talking about in the courtroom, then yes, absolutely. I think the president could use the First Amendment as a defense. Is it going to be successful? Let's remember a couple things. One, we have a very strong First Amendment tradition in our country. And what stands at the top of the First Amendment? Political speech. So we are worried about infringing on that. But let's also remember, as you said, that there are limits. It's not actually that no law means no law under the First Amendment. What's one of them? Inciting violence. You cannot be specific and tell people, here's what I want you to do, commit this crime. So you can rev up an audience. You can say, a terrible thing happened, the election was stolen. You can be general, but if you start getting into the specifics that I think President Trump walks into and say, and here's what we're going to do about it, that's when you're starting to walk towards that line of inciting violence, of inciting an insurrection. And that's what we're talking about here, is those two kind of competing interests.
Professor, let me ask you, so what we've been talking about over the course of the last week is the 25th Amendment or impeachment. But there are some lawyers who see an alternative, a third alternative. And it's examining a little-known provision of the Constitution, which is Section 3 of the 14th Amendment. Now, for those like myself who are not lawyers, I mean, when I hear 14th Amendment, I, of course, think immediately of providing citizenship and equal protection under the law to anyone who's born here or who's a naturalized American, and that would be me. But there is a section of that 14th Amendment that some lawyers are looking at that can provide an alternative to the other two. What is it?
Yeah, you're exactly right. When people think about the 14th Amendment, they think equal protection, they think due process. They don't think about this little used section that was implemented after it was essentially used so that Congress would not seat members who were elected from the unreconstructed South. And the idea is that what the language says is that those who are, and you can see it on the screen, engaged in an insurrection, essentially, or those who support an insurrection, those who aid and abet the enemies, could not be senators, could not be representatives, could not hold high office in the United States. Now, two interesting things, well, lots of interesting things, but two main things for your viewers to focus on. Number one, it doesn't specifically list the President of the United States, and it does specifically list other offices. So unclear as to whether it applies to the President. I think the better reading is that it probably does. Two, we've never used it in this situation. We don't actually know if it's self-effectuating or not. I don't think we're going to go down this road. It would essentially mean you cannot hold your office. And then Congress, both houses could vote by 2/3 to remove the disability, which I think the better reading means Congress could vote by 2/3 of both houses to say, no, it's okay. But I don't think we're going to use this route. It's untested. It's a little bit vague, but it shows where we are as a country, that we're having a, frankly, semi-serious conversation about it.
So Professor, can I just, to your point, I'm looking at Section 3 right now. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or any state, who, having previously taken an oath as a member of Congress or an officer of the United States or state legislature or executive, shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. So it mentions the electors of president and vice president, but it doesn't mention the office of the president or the vice president. So could the Supreme Court or even lower courts say, you know what, it covers a lot here, it just doesn't cover the executive, and so, like, you don't have a case?
They could.
Well, I think they were primarily raising it in regards to Senators Hawley and Cruz because of their opposition to the Electoral College votes. I think that's because, you know, the conversation was, if you contributed to what we saw on Wednesday, what are the options in terms of, you know, a punishment for that behavior? Sorry, Professor.
No, I was going to say, I think that that's exactly right, that there's an easier case for the people who are, and thank you, there's an easier case for the people who are specifically outlined in that provision, the senators, the representatives. If you think about what this would mean, though, it really would be playing constitutional hardball with the Senate and with members of the House of Representatives. So I don't know that they're prepared to essentially test this provision out. As to the question about whether or not it applies to the president, it's a little bit of flashbacks to a conversation we had a long time ago about the emoluments clause. It doesn't specifically talk about the president, but it probably envisions that it would include the president. Again, I think you're exactly right that the more serious conversation would apply to the senators and the representatives who essentially supported President Trump's positions overturning the election. I'm still not sure that we are there yet, but that is the easier reading of Section 3 of the 14th Amendment.
So before we started talking about the 25th Amendment and the 14th Amendment, we were talking about something you just brought up earlier, this idea that President Trump might want to pardon himself before he leaves office. It has risen up again in conversation. And this would only cover federal crimes, right? But once again, uncharted territory. We don't know what that means. We don't even know if you can do it. But if he would attempt to do it and there would be a challenge then in court, what would that challenge look like?
Right. So if he attempted, essentially, here's what you would need to set up the question. The President of the United States would have to issue a pardon. Then a federal prosecutor would have to charge him for conduct that falls within that pardon. The president would then have to say, not so fast, I have a get out of jail free card. I have this pardon right here in my back pocket. The federal prosecutor would then have to say, that is not a valid pardon. That's a self-pardon. That's not proper under the Constitution. And that's what sets up the live case or controversy under federal law. In order to walk into the federal courthouse, you need to have a live case or controversy, and that would be one. Now, what's on kind of the yes column of the president can self-pardon? The main thing is that the text of the Constitution doesn't say you can't. And the text of the Constitution does say no pardons with respect to impeachments. So if the founders knew how to create exceptions, and they didn't create one here, did they essentially envision a self-pardon? I think the answer to that in the no column is no, they didn't. It goes against the idea that no person is a judge in their own case. No person is above the law. It goes against the idea of accountability. It goes against the idea of self-governance. It goes against, frankly, some separation of powers issues. So I think the better answer is no. But again, kind of third time we've said this today, uncharted constitutional territory. We don't have an answer because no one has ever tried.
And we're talking about a preemptive pardon at this point. There isn't even something to pardon him from. But the idea is that he would preemptively pardon himself as sort of blanket thing. Go ahead, Vlad. Sorry.
No, I was going to say, yeah. I mean, it's remarkable, and it's not just the president, Professor. We've heard reports that he could pardon members of his own family, and again, these are individuals who, as far as I know, haven't been charged with anything yet. But it just sort of makes me wonder. It can't just be, well, they're worried about, the swamp and Democrats coming after them and, Nancy Pelosi and all the boogeymen, that exist in their minds. To me, they've either got to be really concerned that there is something out there that could potentially put them in legal jeopardy, including the president's children, or else why else would he be contemplating something like this?
Well, so I think what the president's response would be is, no, we didn't do anything wrong. I just don't trust the Biden administration. I don't trust the Department of Justice. I think that they would go on a baseless witch hunt, and therefore it's incumbent upon me to protect my family. Now, that's not my particular view, but I think that that would be the response, which is, how could I trust, this Department of Justice? How could I trust a future Department of Justice? And one thing, of course, to remember is that you do not have to be charged with a crime in order to pardon somebody. Think back to probably the most famous pardon, President Gerald Ford of then former President Nixon. He hadn't been charged with anything yet. Prospective pardons, I believe, absolutely are constitutional. You just have to have committed the activity that gives rise to the pardon before you give the pardon. You can't say, and just in case you ever do anything in your life that somebody might think is a federal law violation, I want to go ahead and wave a magic wand and pardon you now. So I think that would be President Trump's talking points. I don't think that that's, not my view as to why he would pardon himself and or his friends, his family. We have seen that he uses pardons essentially to reward loyalty. So
just to be clear then, we could see, so does this cover, would a pardon cover, for example, investigations that are being conducted right now, for example, here in New York State? Would that cover anything that the state of New York or in the state of Georgia, where they're looking at those phone calls that the president placed to election officials? They're investigating that. Would he be covered under this pardon that he could presumably offer to himself? No, the president only has pardon power over federal crimes. And I'm glad that you asked that because it's important to highlight. So the president has no power over state crimes, state investigations. Who has power over that? Governors, because states are, of course, separate sovereigns. The president of the United States can't reach into a state criminal justice system and try to, quote unquote, right those wrongs. That's, again, only the purview of those governors. And so what are we looking at here? There are active investigations in New York, as you talked about. The district attorney, Cyrus Vance Jr., is looking into the Trump organization, is looking into, I believe, President Trump himself, business dealings, and perhaps beyond. There also may be, of course, as you mentioned, investigations in the state of Georgia with respect to the president's phone calls, for instance, with the Georgia Secretary of State, trying to engage in conduct that I believe would get close to, if not constitute, election fraud, saying, find me more votes. So those investigations could go forward. He could be tried, convicted, and a pardon would not be able to touch that.
What about other legal challenges, maybe not criminal legal challenges, but once the president is out of office, the president is a businessman. We know one of the things that's very sort of complicated about a businessman who's also the president is conflicts, violations, the emoluments clause that you brought up. And there's been all these sort of investigations looking into whether or not there was a violation of the emoluments clause. I don't think much has come out of that, or that I'm aware of anyways. But I wonder if after he leaves the presidency, if we may find him facing some civil lawsuits based on some of the activities that occurred while he was in the Oval Office.
Yeah, absolutely. And again, this is the world of hypotheticals, so I'm not privy to all of the investigations and what is going on. So I just want to create that caveat here. But if we look back to Michael Cohen's testimony, Michael Cohen, of course, the president's personal attorney, and we look back to what he said, what could we be looking at here? Both criminal violations and potentially civil exposure for things like tax fraud, insurance fraud, issues with banks, perhaps misstating information in order to try and obtain loans. There could, of course, be issues related to the Trump organization itself. Not clear that all of those would give, or any of those would give rise to criminal violations, although there are ongoing criminal investigations. But yes, I think those are along the lines of what we would think about for civil penalties. Again, tax issues, insurance issues, more of kind of financial issues.
Jessica Levinson, this has been a really interesting conversation. I know that some of it is sort of academic maybe at this point, but it's still sort of a fascinating area to explore. Appreciate having you.
I had a great morning with you. Thank you for having me.
Thanks, Professor.